direction of any person or authority. Yet, the provisions in the Constitutional Amendment Bill on delimitation of constituencies explicitly direct IEBC on how to perform its functions. It directs the IEBC on what to do, how to do it, and when to do it with regard to the newly created constituencies. It requires no belabored analysis to conclude that this is an explicit subversion of the constitutional edict that IEBC shall not be directed on how to perform its functions. Second, the Constitutional Amendment Bill not only unlawfully takes over the functions of IEBC, but it also allocates constituencies in violation of the constitutional principles set out in Article 89, which IEBC is obliged to adhere to in executing its mandate. The Constitution at Article 89.5, 89.6, 89.7 clearly sets out that it is the IEBC to conduct the process of delimitation and also sets the criteria to be used. We have reproduced the procedure and criteria that the IEBC is obligated to use above. Yet, the Constitutional Amendment Bill directs the IEBC to determine the boundaries of additional constituencies by using the criteria provided for in Articles 81D and 87.7. This is Section 1.1 of the second schedule to the Constitutional Amendment Bill. On the other hand, Section 1.3 of the second schedule provides the IEBC to prioritize the constituencies and are represented in the National Assembly on the basis of population quota and to make delimitation decisions in a manner that ensures the number of inhabitants in a constituency is as nearly as possible to the population quota. Article 81D provides that the electoral system shall comply with the principle that universal suffrage based on the aspirations for fair representation and equality of vote. And section, it's about, sorry, there's a typo there. So it's about electoral disputes, and it is not related to Article 89, Article 89 of the Constitution. And then Article 87 does not have subarticle 7. So there's a problem with even the law that is cited under which IEBC is being directed to carry out its functions. So what emerges from the above is that the Constitutional Amendment Bill sets its own criteria on delimitation by citing Article 81D. This is a criteria unknown as a delimitation consideration in the Constitution. It refers to an non-existent criterion in the form of Article 87.7. Reduces all the consideration listed in Article 89.5, 6, and 7 to a single one, namely the population quota, as the basis for the delimitation decisions with respect to the 70 additional constituencies. By doing these three things, the Constitutional Amendment Bill seeks to short-circuit Article 89 by apportioning the newly created constituencies to specific counties and then directing IEBC, in essence, to delimit boundaries based on a single criterion. This is contradistinguished to the several criteria specifically set out in the Constitution at Articles 89.5, 6, and 7. This renders the proposed amendments in this regard irregular, illegal, and unconstitutional. The third reason the provisions on apportionment and delimitation of the additional constituencies are unconstitutional is that they purport to create a process of delimitation which ignores an irreducible constitutional consideration, public participation, stakeholder engagement, and consultation of interested parties. There is no doubt that the Constitution requires IEBC to conduct public participation, consult interested parties, and engage all affected stakeholders when carrying out its delimitation mandate. Article 89.7a is explicit in requiring the IEBC to consult all interested parties. We have gone on to reproduce Section 36.4 to 36.11 of the IEBC Act, which deals with that process. These provisions are clear on the requirement of public participation and stakeholder engagement in the delimitation exercise. Indeed, they require public participation and stakeholder engagement not only during the process of delimitation itself, but even after the IEBC has published its preliminary report and before publishing the final one. This robust requirement of public participation and stakeholder engagement only accentuates the requirements in Article 10 of the Constitution. Despite these clear requirements in the Constitution and the statutory law, the Constitution Amendment Bill ignores the requirements of public participation and stakeholder engagement. This is in conflict with Article 89(7), the national values and principles in Article 10(2), and Section 36 of the IEBC Act. These two renders the Constitution Amendment Bill unconstitutional. The fourth reason the Constitution Amendment Bill runs afoul of the Constitution is that it stipulates a timeline for the delimitation which is in conflict with the one created in the Constitution. Section 1.1 requires the IEBC to determine the boundaries of the additional 70 constituencies within 6 months of the commencement of the intended act. However, Article 89(2) gives the timelines for review of boundaries. Among other things, it requires the IEBC to review boundaries of constituencies at intervals of not less than 8 or more than 12 years. But Article 89(4) requires IEBC to complete the review of boundaries not more than 12 months to the next general elections if the new boundaries will take effect for purposes of those general elections. The present Constitution Amendment Bill, however, at Section 1.6 of the second schedule, purports to suspend the operation of Article 89(4) of the Constitution by providing that, quote, the requirement in Article 89(4) does not apply to the review of boundaries for the additional constituencies preceding the first general elections from the commencement date of the intended act. What the explicit terms of these provisions propose to do is to permit the IEBC to begin and complete the delimitation exercise outside the timelines expressly provided in the Constitution. It only requires the IEBC to do the review within 6 months from the date of commencement of the Act, even if those 6 months come within the 12 months of the general elections. These provisions are plainly unconstitutional because they impermissibly purport to suspend the operation of a constitutional provision which, given the history we have provided above and the text and context of the Constitution, forms the basic structure of the Constitution. Indeed, we plainly find that the provisions of Article 89(2) to 89(12) are eternity clauses and unamendable. It is for this reason that we have also concluded that the procedure and process that the promoters of the Constitutional Amendment Bill have used to create, apportion, and delimit the proposed 70 new constituencies amounts to an impermissible extra-textual amendment to the Constitution by stealth. We say it is an attempt to amend the Constitution by stealth because it has the effect of suspending the operation of Article 89 without textually amending it. The implications of such a scheme, if allowed, are at least twofold. First, it creates a constitutional loophole through which the promoters can amend the basic structure of the Constitution without triggering the primary constitution.